Good morning to everyone. We kindly request that you proceed to take your seats so we can begin with the conference. Good morning to everyone. We kindly request that you proceed to take your seats so we can begin with our conference. Good morning to everybody. We kindly request that you proceed to take your seats so we can begin with the conference. Buenos días a todos. Los invitamos a pasar a tomar sus lugares para poder comenzar con la conferencia. Buenos días. Los invitamos a pasar a sus lugares para poder comenzar con la conferencia. Dear all, we will begin with our conference shortly. We invite you to proceed to your seats. We kindly request from everyone to take your seats. We will begin shortly. Muy buenos días a todos. Los invitamos a pasar a sus lugares. Good morning to everybody. Before we begin with our event, I would like to request that you please direct your attention to the screen in front, in which we will play a video reviewing our emergency procedures.
Cofece's Internal Civil Protection Unit welcomes you. You are in the auditorium on the 14th floor of the Anante Tower. In case of emergency, follow established protocols in the Emergency Action Plan. In case of an earthquake, for your safety and that of others, always stay calm. When listening to the seismic alert for earthquakes, immediately move to a lower risk area. Do not run and do not push. If you are located at the front of the auditorium, please move to the walls. If you are in any other area, please go to the lower risk areas located outside the auditorium. Stay in lower risk area. Take self-protection measures. After the earthquake, do not leave lower risk area until you're instructed by the brigade members. In case of fire, stay calm. If you detect smoke, manually activate the alarm at the station. Pull the handle down. Immediately exit the auditorium. Do not run and do not push. Follow the evacuation route to get to the emergency exit. At the emergency exit, you will find a stairway that will take you to the lobby. Upon arriving there, follow the indications by brigade members and go to the meeting point. In case of other emergencies, always remember to stay calm and follow instructions from brigade members. Cofece thanks you for your attention and wishes you a safe stay.
Thank you for your attention. On behalf of the Mexican Federal Economic Competition Commission and the American Bar Association, it is my pleasure to welcome you to our second day of activities in this joint event from Cofece and the ABA regarding current trends and challenges of leniency agreements in private actions. To begin with today's activities, I would like to present Acting Chairwoman Brenda Hernandez and Ms. Melinda Coolidge, who will deliver a welcome message to us all. Brenda Gisela Hernández Ramírez holds a Bachelor of Law degree from the Escuela Libre de Derecho and an MBA in International Law from the University of Bologna in Italy. She was appointed by Congress as Commissioner of the Federal Economic Competition Commission from 2016 to 2025. As of September 10, 2021, she assumed the position of acting chair commissioner in terms of Article 19 of the Federal Law of Economic Competition, a position that she will carry out as long as the federal executive appoints a new president commissioner. Brenda has extensive experience in antitrust issues. She has held various positions within the defunct Federal Competition Commission, the Mexican Federal Telecommunications Institute, and the Investigative Authority of Cofece. As part of her international activity, since September 2020, she's a member of the Board of Directors of the International Competition Network, and since November 2022, a member of the Bureau of the Competition Committee of the Organization of Economic Cooperation and Development. Brenda also serves on the Board of Directors of Women at Competition Americas, a platform for women specialists in competition in North, Central, and South America. Ms. Melinda Coolidge represents large companies and direct and indirect product procurers that have been subject to antitrust violations around the world. She has litigated complex class actions through the hurdles of class certification, summary judgment, and trial. In her cases, the clients and classes she represents have obtained over $1 billion in settlements, and in one recent case, a 9-0 victory in the United States Supreme Court of Justice. Melinda works hard to enforce the United States antitrust laws and to safeguard free and open markets. Ms. Coolidge is proud to have been named one of the top 100 women in antitrust by Global Competition Review. I hereby give the floor to Acting Chairwoman Brenda Hernandez.
Good morning, ladies and gentlemen, and welcome to the event on current trends and challenges of leniency agreements and private actions. I thank the members of American Bar Association who are with us today, particularly Andrea Verola, Melinda Coolidge, Alfonso Miranda, and Carlos Mena, who will share with us the experiences on the application of leniency programs under current challenges. Economic cartels are considered harmful per se to competition and therefore consumers and the economy in general. International estimates suggest overpricing of more than 20% as a result of cartels, which are collusive agreements that are mainly carried out in concealment in order to avoid detection by the competition authorities. For this reason, competition authorities like Cofece have several tools to detect cartels, such as immunity or leniency programs. These programs offer cartel participants the opportunity to report their collusive conduct, to seize the conduct, to provide information and evidence, and to cooperate in the investigation conducted by the authority in exchange for full immunity or a reduction in the antitrust sanctions. Also are intended to induce cartel members to come forward and disclose the existence of a cartel, and hence, for competition authorities to gather internal information in order to increase the quality of the evidence obtained and allow to plan more effective down rates. For all these, leniency programs increase the likelihood of imposing sanctions to cartels. Today, most competition authorities around the world have these sort of programs in place, and most of these are designed around 3 principles that make them attractive. These principles are clarity on the benefits of the program, fear of detection by the competition authority, and the credible threat of a severe sanction. In some cases, the existence of criminal sanctions may also be an important factor to be considered when deciding whether or not to apply to a leniency program, especially if it also grants criminal immunity. In Mexico, the leniency program was created in 2006, probably one of the first programs in the Latin America region, and was designed based on international best practices. Also, the sanctions imposed to cartel participants were increased, and the program has been improved through reforms to the competition law in 2011 and 2013. In fact, in 2011, the first guide of the program was issued, providing legal and procedural certainty to potential applicants. And the program received 600% more first-in applications than the previous year, which demonstrate the usefulness of this cartel detection tool. Also in that year, criminal sanctions were introduced for cartel participants. Then in 2015, we published a new guide to the leniency program, resulting in 25 national applications. That's the highest number in the history of our program. With no doubt, in Mexico, as in other countries, the leniency program has contributed to a significant increase in the number of cartels detected and sanctioned. However, the current trend in Mexico, as well worldwide, of leniency application have been downward. According to data from the Organization for Economic Cooperation and Development, the OECD, in 2015, the number of applications worldwide was 577, while in 2020, they decreased by almost half, reporting 210. This downward trend was similar in the Latin America region, where 53 total applications were reported during 2015, decreasing only to 18 in 2020. There are several explanations for this decline. Collusion detection is becoming more and more challenging, as it may be facilitated by technologies such as algorithms that make detection more difficult, and therefore, without the fear of detection, there is no incentive for this for the leniency program. Another possible explanation for this decline in the number of applications is the topic that calls to discussion today, correspond to decrease in some jurisdictions of private actions, individual or collective. These actions may have a deterrent effect and discourage potential leniency applicants because disclosure rules regarding leniency documents may allow evidence provided by the applicant to be used against the applicant itself and in a private action. In addition, private actions may pose a threat to leniency programs because they depend to a large extent on decisions to sanction cartels taken by the competition authorities, which in several cases may have been derived from a leniency application. Therefore, self-incrimination of leniency applicants may have a negative consequence in follow-on damages litigations in civil courts. Consequently, the fall in applications may affect the ability of victims to obtain compensation, thus creating a vicious circle where more cartels may go undetected. For this reason, I consider very important the following two segments of today's event, where international best practices to strengthen the incentives of leniency programs will be discussed. And later, it will be shared the international experiences and lessons learned in other countries regarding the interaction between private actions and competition law enforcement with leniency programs. Finally, I would like to mention that our program is a useful and powerful tool, but it's not the only one that we have for this anti-competitive conduct detection. The strategy for detecting, investigating, and sanctioning anti-competitive conduct, such as cartels, has been addressed from several fronts. For example, one proactive tool is the Data Lab project created by the Market Intelligence Unit, which uses a specialized infrastructure on an arrangement of several tools that facilitate virtual environments, big data operations, as well as design of algorithms to explore the functioning of specific technologies and assess the potential impacts on competition. The Data Lab projects allows the Commission to explore how algorithms or search engines work, the access algorithm pricing, and to experiment with artificial intelligence and machine learning techniques. It is worth noting that before implementing the Data Lab project, another in-house tool was designed for public procurement screening, and which has yielded promising results in cartel detection and the opening ex officio investigations. To conclude, these examples of proactive detection, in addition to making our leniency program more attractive, ensure that Cofece rigorously enforces competition law and more efficiently investigates and sanctions cartels and other anti-competitive conducts that harm competition to markets and adversely affect consumers' welfare. Thank you very much.
Thank you, Chairwoman Hernandez, for your message. I would like to invite Ms. Melinda Coolidge to share her welcome message.
Thank you for the introduction. My name is Melinda Coolidge, and I serve as the co-chair of the ABA International Cartel Task Force and as the U.S. managing partner of Hausfeld, which is a private law firm in the United States and Europe that litigates private actions to recover damages caused by anti-competitive conduct for victims. I want to thank Commissioner Hernandez and the other members of Cofece for hosting this conference and inviting the International Cartel Task Force from the American Bar Association to join you. I think it would be helpful if I give you all a sense of what the International Cartel Task Force does and has done. We were created in the late 1990s to facilitate a dialogue between competition authorities and lawyers around the world, geared toward developing, refining, and strengthening civil international cartel enforcement practices. In its early years, the task force served as a resource for competition authorities that sought to bring consistency and predictability to their emerging leniency policies. And members of the task force dialogued with enforcers to illuminate the practices that had encouraged their clients to seek leniency with various enforcers around the world. Competition authorities reported that the information they learned from their interactions with the task force enabled them to refine their policies and procedures to enhance cartel enforcement, including by encouraging successful leniency applications. The members of the task force are hand-selected by the chair of the antitrust law section of the American Bar Association based on their status as knowledgeable specialists who will seek to advance cartel enforcement around the world. Task force members regularly advise their corporate clients on cartel laws and leniency procedures around the globe, and thus have experience with and expertise on the differences between jurisdictions. Many members are former government enforcers, and two, Matthew Boswell of Canada and Alex Cordero of Brazil, are current enforcers. And some, like me, represent claimants in private enforcement actions. In the decades since its founding, the task force has continued to engage in meetings and hold conferences with enforcers, in addition to responding to requests for comment or feedback on proposed laws and enforcement policy changes. So today, we'll examine together the state of competition enforcement in Mexico and around the world. Mexico, primarily through Cofece, has developed a number of policies and best practices regarding leniency that serve as a model for the rest of the world. Yet still, Mexico, like all active competition authorities around the world, have seen leniency applications decline in recent years. And so we, all of us who are committed to antitrust enforcement, are here with you today to hypothesize and examine why leniency applications are decreasing. Some may hypothesize that changes to leniency programs have made the process less predictable and made it harder for attorneys to recommend that their clients seek a marker and attempt to obtain leniency. I know that several of my colleagues on the International Cartel Task Force believe that the US DOJ's recent perceived weakening of the Golden Rule makes leniency much less attractive to potential applicants. In other words, if they advise their clients to seek a marker with the DOJ and to provide all the cooperation necessary to perfect that marker, they want to be able to ensure their clients that they won't be worse off than any other cartel participant. And that makes sense to me. They've earned it. But if at the end of the day, the first in gets a worse deal than others, it becomes much more difficult to recommend participation in a leniency program to future clients. I understand this. Others may believe that shifting priorities within competition agencies with a focus on reining in technology companies with global dominance or anti-competitive practices within labor markets have caused the decline in cartel enforcement. And we'll be discussing another one of these theories, which Commissioner Hernandez touched on herself this morning, that the risk of civil damages actions are the reason for the decline in leniency applications. As a litigator of civil damages actions at a firm that brings these claims on behalf of large corporations and collectives in Europe and the United States, I'm of course particularly intrigued by this theory. The US has always had a robust system to seek civil damages, either through independent civil actions or through class actions. And the US has also typically had large numbers of leniency applicants. The point of the civil damages system, of course, is to ensure that when consumers or businesses suffer from cartel conduct, namely by paying the higher prices that were the purpose of the cartel, that not only are those violators punished for their wrongdoing by fines they pay to the government, but that the victims receive compensation for the damages caused by that antitrust violation. Civil damages actions have become more common in Europe over the last decade with a different focus. Rather than small businesses leading the cases as class representatives, like is typically done in the United States, in Europe, the largest corporations with the largest damages were often the ones to bring claims. Only recently have collectives become a viable option, particularly in the UK, allowing smaller businesses and consumers to also seek compensation for antitrust violations. In any event, it is these damages actions that some now blame as the reason that cartel participants no longer want to seek leniency. The consequences would be too great to make leniency worthwhile, they say. Instead, as the theory goes, these cartel participants are faced with the difficulty of withdrawal from a cartel without triggering other participants to rush in for leniency, or just hoping they don't get caught. It's an interesting theory and one I'm sure we'll talk about more throughout the day today. And finally, my personal favorite theory, when I put away my cynical mind and embrace the role of a full-throated optimist, that we have all just been so successful at educating business people about the dangers of engaging in cartel behavior that no one is attempting to fix prices anymore. I'd really like to believe that's the answer. I'm perfectly happy to be put out of a job if it means markets are working as they're supposed to, competition is fierce, and innovation is happening left and right. But I think very few people in this room would honestly endorse this optimistic view. Whatever the reason for declining leniency applications, there is no better group of lawyers and economists and others than those in this room to ferret out the cause and to design the solution to ensure that anti-competitive activity is interrupted and victims of anti-competitive conduct are compensated. Collectively today, we'll examine our systems of incentives and deterrence, compensation and punishment to build stronger global markets where competition can thrive. Thank you again for joining us here today. I look forward to the conversation.
Thank you very much, Ms. Coolidge, for your message. On behalf of the Mexican Federal Economic Competition Commission, I would like to thank you both, our speakers, for sharing their messages with us. We will resume our activities with a presentation from our keynote speaker, André Gueverola, speaking about strengthening incentives for leniency agreements. Mr. André Gueverola is a partner at Arnold & Porter, where he heads the firm's cartel investigation practice. He was the first director of criminal litigation in the Antitrust Division of the United States Department of Justice, where he supervised antitrust litigation matters across the country and helped formulate critical policies and practices that impact leniency applications, grand jury investigations, and compliance programs. Earlier in his career with the Antitrust Division, Mr. Gueverola worked as a trial attorney and later as a chief assistant in the Chicago office of the Antitrust Division. In these roles, he led numerous investigations and prosecutions of antitrust and fraud-related crimes and was responsible for the largest corporate criminal cases in the office history. Before giving the floor to Mr. Gueverola, I would like to remind our audience that at the end of his presentation, there will be time for questions, which we kindly request to be made in English as a courtesy to our speaker. Without further delay, I would like to welcome Mr. Guevarola to share his ideas with us.
Good morning, everyone. So what I'll be speaking about today is leniency programs and how to strengthen those incentives in light of what you've heard, which is applications are down, and we, the International Cartel Task Force, and others are trying to think about what the root causes are and how to improve that situation. But before I do that, it'd be helpful to get a sense of the audience. So if you could just raise your hands. How many of you are with Cofece? Thank you. And how many of you are private in the private sector? Great. So we've got a good mix of enforcers and private sector folks. That's really helpful for this discussion, and I do want it to be a discussion. So while there will be time for questions later, please don't feel the need to wait. I want this to be more of a conversation, so if you have thoughts, if you have questions, just raise your hand, and please engage with me in this conversation. It'll be a lot less lonely up here if you're talking to me. So just a little bit of background in terms of US cartel enforcement, because that's the experience that I'll be drawing from today. Cartel enforcement in the US is a criminal matter. It's not an administrative proceeding. The investigations and the prosecutions are all done criminally through the federal courts, and the penalties are criminal, whether it's criminal fines or prison time for individuals. And as you heard, I spent quite a lot of time in the US, around 14 years being a prosecutor of these types of crimes. So I'm familiar with the cases from that perspective. So first, just a little bit of background about the US leniency program for cartel enforcement. The policy was issued in 1993. And does anybody recognize who's on this slide? And the reason I put Whitney Houston on is because in 1993, her song, "I Will Always Love You," was the #1 song in the United States. So I thought that was kind of a nice marker for the birth of the leniency program, or I should say the modern leniency program, because there was a predecessor leniency program in the United States before 1993 that nobody ever took advantage of. The reason for that was the program is highly discretionary, not very predictable, not very transparent. So although it existed in the books, in practice, no one really used it. But in 1993, the Antitrust Division modernized this program and created the new corporate leniency policy. The main factors for that policy were essentially if you are a leniency applicant and you're successful in your application, you would receive immunity for both the company and its employees from prosecution. And again, this is criminal prosecution. And the program itself set forth 6 or 7 factors depending on the situation, whether it's what we call type A leniency, which is when the applicant comes in before the government is aware of the conduct, or type B leniency, which is what happens when an applicant comes in after the government has already been made aware of the conduct. But the main goals and features of that program are, one, creating those strong incentives for self-reporting, because if you're a company or if you're a lawyer advising a company, why would you ever bring your client into the government to confess a crime? What's the benefit to that? So the incentive was to protect them from prosecution as a way to encourage companies to come forward and inform the government of the crime. And the benefit to the government is, because these are cartels, there's not just one party involved, right? There will always be a second, a third, a fourth company involved in the cartel, and the benefit to the government is that it can then have evidence to prosecute those companies. But key to this program is it has to be predictable. So when a company comes in, they should know what they're getting out of it. They should also know what their obligations are to get that benefit. And two, it has to operate transparently so that at each step of the way, the company knows its situation and can make decisions accordingly, again, to make it as attractive as possible for companies to come in. Of course, the leniency program hasn't been static since 1993. It's developed and evolved over the years. I'm going to cover some of those today, including ACPERA, which you'll be hearing about, I think, a lot more in the next session. And then some updates to the frequently asked questions that basically explain what the program is. And also note that in addition to the original corporate leniency policy, there were additional features added over the years. For example, individual leniency. That was added by the DOJ so that if an individual wanted to come in and self-report, even if their company doesn't want to do it, they can do it and obtain protection. And two, what's called the leniency plus or amnesty plus policy, which basically means if you've been kind of caught with one cartel, one thing we've learned over experience is when a company is engaged in one cartel, it's probably not limited to that. They probably have other places in their business where they're engaging in other cartel conduct, because if the culture allows it in one place, it probably allows it in others. So the leniency plus policy was basically to encourage companies that have already been caught in one cartel to self-report the other cartels that might be involved in. And the flip side of that is called penalty plus, which basically means if you got the opportunity to self-report the second cartel but you don't do it, we will punish you more severely. To really incentivize those companies to come in. So I'll just go through these in order. ACPERA was passed in 2004. Again, really kind of as a supplement and as a way to amplify the leniency program. Some key features of ACPERA are, one, it increased the criminal penalties for cartel violations to 10 years in prison for individuals. Previously it was 3. And it increased the maximum fine for companies to $100 million. And in fact, over the years, cases have exceeded even that maximum, sometimes by many hundreds of millions, because the law in the United States also allows for fines based on double the gain or double the loss from the offense. So if you pay attention to DOJ results, even though the statutory maximum is 100 million, you'll often see, 5, 3, $200 million fines. I think one of the biggest case I worked on was a $425 million fine. And the other key feature of ACPERA was it protected the leniency applicant in the civil damages portion of the case. So, you heard that Melinda practices on the civil litigation side, representing private claimants who are victims, or if I'm on the opposite side, I would say alleged victims of the cartel. And in those cases, the liability is called treble damages, basically triple the damages. It's also joint and several, which means you're liable for the whole thing. So the protection extended to leniency applicants was basically you get single damages, as a cap, and also your damages are only limited to your particular conduct and your particular sale, so you're not responsible for the damages caused by others in your cartel. So that was a way to limit the exposure for leniency applicants, and again, to make their exposure more predictable, because they can figure out what their sales are. They don't necessarily know what somebody else is selling. And by coming into self-report, they're essentially admitting the conduct and potentially creating liability for themselves. So this is an effort to make it more predictable. The obligation of the leniency applicant is to cooperate with the private claimants to get that benefit. And as you've heard, there's a debate now going on in terms of whether ECPARA is still serving the intended purpose and whether it's helpful to leniency applicants, but I think we'll save that for the next session. So again, continuing along this development of the current program, the DOJ published frequently asked questions and answers in 2008, basically to really kind of explain not just the policy, but the practice of the leniency program. So questions like, what's a marker? How do you ask for a marker? When do you get a marker? When do you get your conditional leniency letter? So just very kind of nuts and bolts questions and answers for how things work in practice. Again, the goal is to provide as much clarity and as much transparency as possible to companies and maybe individuals considering leniency in terms of how it would work if they were to come in. All good news so far. So around 2017, or in 2017, there was a new set of FAQs. Around that time, or shortly before, I think this was in 2015, the DOJ issued what's called the Yates Memo, named after Sally Yates, who was the Deputy Attorney General for the Department of Justice. This is the #2 position in the Department of Justice at the time. She issued a memo basically saying, when we're talking about corporate crimes, what I want the focus to be is on the individuals committing that crime and how we investigate and prosecute those individuals, because as we all know, companies can only commit crimes through their employees, right? Those are the people actually committing the conduct, and if we're going to deter those crimes, we need to deter those people. And I think there was also a notion that companies may be willing to pay a fine as a cost of doing business. If you can commit a crime very profitably and pay a fine that's smaller than the money you made, then maybe it's worth it, except when people start going to jail. And if you just think about the timing of this, this was at the tail end of the financial crisis, where stock market went down, there were a lot of investigations, companies were fined, but no senior financial executives were ever prosecuted for any of the conduct that caused or contributed to the financial crisis. So there's, I think, a kind of a political recognition of, well, that doesn't look right, what do we need to do? And DOJ leadership focused on, well, let's make sure we focus on those individuals who make decisions for companies. And as a result, for the leniency FAQs, there were some slight changes, the main one being for type B leniency, so leniency after the investigation has begun. The division reserved the right to prosecute highly culpable individuals. So basically the senior executives that might be directing the conduct. And that's a change to the past practice where if you come in for leniency, presumptively anybody who cooperates in your company is going to be immunized. So here there's now at least a subset of people that may not be immunized even if a company has come in and successfully obtained leniency. I think this brings to mind kind of, I think, a tension between the leniency program and kind of overall DOJ practice. Overall DOJ practice is, if you have culpable individuals committing crime, you prosecute them. And the leniency program really is, in some ways, the reverse of that, because individuals are immunized from the crimes that they committed if they're willing to come in and cooperate through their company. So there's that kind of always tension, kind of pushing against each other in terms of, well, we want to make sure those individuals are punished because they're responsible for the conduct, but we also want them to come in and cooperate with us, because if they don't, then how can we investigate and prosecute this conduct? So that's the tension for DOJ that I think DOJ is constantly trying to rebalance, for better or worse. I think that some of these issues are ones where, practitioners like myself think they may be pushing too hard into kind of punishment and not enough into the incentives to come in and self-report. So that brings us to 2022. The previous one was under the Obama administration. Now we have the Biden administration, also focused on corporate crime and making sure corporate wrongdoers, especially senior executives, are held accountable for those crimes. So again, the leniency program was updated. There were some other broader DOJ updates as well that I'll talk about. But in terms of the leniency updates, earlier I told you that in 2017, the antitrust division essentially carved out a subset of employees in the Type B situation where those employees can be prosecuted. Now in 2022, every employee under Type B can be prosecuted. So it's no longer a subset. Where it is now is, if you're a Type B leniency applicant, none of your employees are presumptively covered as part of the immunity application. Now, the DOJ still retains the ability to give those individuals protection if it decides to do so, but now it's discretionary for those individuals. So again, that's part of this kind of movement towards making sure individual wrongdoers are punished, but at the expense of reducing incentives possibly for companies to come in, because if you're in a Type B situation, now you have to think, well, are they going to come after my CEO? Are they going to come after other senior executives? Is it worth it to come in, or should we kind of just stay quiet and not self-report? So it affects the incentives for companies. Some other features, I think, that also further raise the bar for leniency applicants is one, there's now a prompt reporting requirement. In the past, as long as you promptly terminated the conduct, if there was a delay in reporting it to the government, you could still qualify for leniency. But now there's a requirement that after essentially the conduct is discovered, you have to promptly come in and report. And if you delay that reporting, you may not be eligible for leniency. So for companies where there's some lag between discovery and kind of the decision to report, that's a disincentive to come in. Because you think, well, I'm not sure if I'll meet that standard, and if I don't, I'll get prosecuted, so maybe I'll rethink the decision to come in. Two, there's a remediation requirement that basically says you have to change practices within your company to make sure this doesn't happen again. So whether it's enhanced compliance programs, which many companies already do when they discover this kind of conduct, or sometimes remediation can mean you have to fire the people involved in the conduct, because those are the people that are most likely to kind of continue or return to that type of behavior. So again, companies need to think about that when they're making the decision to come in. You know, it's not just about cooperating with the government, it's also we need to make corporate changes internally. What will those changes mean? And what will be good enough for the government such that we can keep our leniency? And third, there's a revised restitution requirement. And let me be clear, there's always been a restitution requirement for leniency applicants. You have to pay restitution to your victims after you admit the conduct. What changed in 2022 is that decision is happening much, much earlier in the life cycle of the investigation. So in the past, restitution was a question that you basically deal with at the very end. You have much more information about other companies being prosecuted, whether there's civil damages actions that you need to deal with. And that's the time where you make the restitution decision and kind of how you're going to meet that obligation to the victims. Now that decision needs to be made much earlier, essentially at the conditional leniency stage, not at the final leniency stage. And that's the reason that's difficult for companies is at that time, there may be nothing public about the investigation. The DOJ may not have pursued any of the other companies yet because they're still investigating. It's happening much earlier. You have much less information, yet you have to stick your neck out to basically work out kind of how you're going to pay restitution and potentially have to contact your customers and say, hey, you know, we committed this conduct, we want to make it right, you know, let's work out what we owe you. But companies are a little reluctant to do that when you don't know what might be happening downstream, because DOJ may very well decide they don't want to pursue criminal cases for whatever reason. Maybe the evidence isn't good or it's old, but now you've stuck your neck out and called yourself a legal violator when nobody else might be doing the same. So these are different recent factors that I think raise the bar for leniency applicants in a way that might affect their decision making when they're thinking about coming in. So there's other recent changes around this time frame. One, in terms of leniency practice, this isn't in the policy, but the current practice is if you're going to come in as a leniency applicant, and if your employees are going to be covered by that, part of their cooperation obligation is to engage in what's called affirmative investigative techniques. What that basically means is if the government wants them to make a recorded phone call or go to a meeting with a wire, I think we've seen in the mafia movies where somebody walks in with a wire kind of strapped to their chest or their back. If the government wants them to do that, that's part of their obligation to cooperate if they want to be covered by the leniency agreement. And that's a scary prospect for a lot of people. Another change is there's now an explicit requirement not to contradict your leniency admission and public statements. And what's driving that, I think, is this notion that a company may want leniency, but in kind of parallel civil litigation that might be occurring, they're also trying to minimize how much they need to pay there. So they might say things that kind of minimize their admission or contradict their admission. So the DOJ has made this an explicit requirement that, hey, if you're going to come in and admit the wrongdoing, you can't go into a different venue and say things that are in conflict with that admission. Now, there's a consequence to that, or at least maybe an unintended consequence, which is once you've come in for leniency, you're basically stuck with liability in the civil case, right? Because now you can't deny, there are limitations on what you can deny in the civil case. It's not every denial, because you might say the civil case is different from the leniency application, but there's much less room for you to defend the civil case because you've made this admission, and if you were going to contradict it, you could get kicked out of the leniency program. And as I said, with the new administration coming in, they're really also kind of focused on individual wrongdoers, much in the same way that I described earlier. Another kind of, I think, interesting fact from last year is that the leniency model of self-disclosure is really getting kind of exported throughout DOJ. Part of the guidance from, this is not Whitney Houston, this is Lisa Monaco, the current Deputy Attorney General in the United States. The guidance from her is basically to encourage all DOJ divisions to create self-disclosure programs, in some ways modeled after a leniency, but in some ways different. But I think really kind of the underlying belief is a recognition of the success of the leniency program, that now DOJ wants other components to have something similar. But as these components develop their own programs, there may be differences across the programs that might affect how the antitrust leniency program works. One example is the no individual coverage for type B, for example. In other components of DOJ, it's very unusual, if not non-existent, for a company resolution to ever cover employees. It's just not done. Whereas the leniency program includes that as a key feature. So in terms of reconciling, one potential consequence is what you see in type B, which is individuals no longer are covered. So kind of that's the overview in terms of what's happened in the US over the past, 30 years. I thought I'd also talk about some case examples, because I think it's always helpful to ground these concepts in real life cases. So we'll talk about 3 examples. So the first one is auto parts. Many of you have probably heard about this. This is, I think, probably the biggest cartel investigation, or I should say investigations, because there are multiple investigations that DOJ has ever done. And like I said, the results are undeniable. Over 100 companies and individuals were charged. Almost $3 billion US in criminal fines. Over 30 individuals were convicted and served prison time. And they served prison time from roughly 1 to 2 years. And an interesting feature is that a lot of these individuals lived overseas and voluntarily agreed to come to the US to serve their time. And I think it's been reported that a lot of these matters involve leniency. So I'll keep my comments to the public record given my time at DOJ, but I think that's public. But I think an important point here is the success of leniency plus as a model. Because really what happens is you start with one investigation, you have one leniency applicant reporting about other companies. Once you start investigating those companies, they might report new cartels with a different set of companies. So you really, start from maybe one group, and it grows from there almost exponentially to many, many companies, many, many individuals. And that's a testament to the success of leniency plus, which gives those companies incentives to basically report on the new cartels or the unknown cartels that they may be involved in. As I said earlier, the largest case I ever worked on was against Bridgestone Corporation, the large multinational company. Their ultimate fine was $425 million. And this is public in the court papers. They paid an extra $100 million because of the fact that years ago, they had a prior settlement with DOJ in the marine hose case, but in that case, they did not self-report the other violation. So penalty plus applied, and as part of this, the penalty calculation, their fine was increased by $100 million. So that's kind of the stark difference between leniency plus, when you can get immunity, and penalty plus, where you might be paying a lot more money because you did not self-report. So auto parts was a very, I think, successful model for leniency. So next, moving forward in time, we have the canned tuna matters at DOJ. And again, this is all public as well. So this matter grew out of actually a merger investigation. So two of the tuna companies were trying to merge, and as part of the merger process, you have to make your merger filing, produce documents as part of that merger filing. And one tip I have for the private practitioner is, if you also do merger work, look closely at the documents you're giving to the government, because if those documents have evidence of crimes, the government will investigate that. And that's what happened here, is that there were documents produced that showed maybe this isn't just a merger case, maybe it's also a price fixing case. And then one of the companies went in for leniency. They made a public disclosure saying that that's what they were doing. So of the three main tuna companies in the United States, one received leniency, the other two were prosecuted. Both companies pled guilty. One paid a fine of, I believe, 29 million. The other paid a fine of 100 million. So significant cases. And then, of course, DOJ doesn't stop there. It also pursues the executives. 4 individuals were convicted. 3 of those individuals pled guilty. And the 4th, who was the CEO of one of the companies, decided he wanted to go to trial. So, he went to trial in a court in San Francisco. This was in the fall of 2019. So I was in my role of director of criminal litigation, so I supervised all the cases, including that one. So I had a nice fall living in San Francisco with a trial team, except we spent most of our time in the office, so I didn't really see much of San Francisco. And in that case, he tried to fight the charges. The big problem for his defense was that the other 3 who had pled guilty were testifying against him, after having admitted their role and the fact that they were admitting the crime and were subject to punishment for that crime themselves. So the jury didn't even take half a day to convict him. I think 4 hours max, probably less than that, was the jury deliberation time before they found him guilty. So again, another very successful investigation. But I think the message here is that these cases can come from different directions. You can have a merger investigation. It does not have to be a type A leniency applicant. You can have a type B leniency applicant coming in as a result of discovering the conduct through other means. Now, moving forward in time to last year, another significant matter for DOJ, this is the broiler chicken industry matter. Again, one company came in for leniency that it's also publicly disclosed, and cooperated. Another company pled guilty and paid a significant fine, $108 million. I don't know, I think that was the last fine I negotiated before I left DOJ. So I thought I left DOJ with a nice parting gift before I left. And then after that, nobody else cooperated, nobody else pled guilty, and everybody else chose to litigate. So in that case, DOJ tried several of the senior executives. In fact, one group of senior executives was tried 3 times. The first time the jury couldn't decide, the second time the jury couldn't decide, and finally the third time the jury found them not guilty. And then some of the other cases were, after that, were dismissed. So none of the individuals were convicted. Like I said, as a result of 3 trials, there were 0 convictions. And I think one important distinction between this case and the other cases is really individuals admitting their guilt as part of a guilty plea. Because that's the difference between this case and the other cases where somebody actually admits the crime, does not receive immunity, but actually is subject to a criminal conviction and testifies on behalf of the government. And that's a big difference between this case and the previous ones. So, I mean, I think the message here is leniency is helpful, but to have an effective cartel enforcement program, leniency is not enough. You have to have multiple ways to develop your case. So now, talking about the current state of leniency, you heard a little bit about the decline earlier, and the numbers are, I think, undeniable. That leniency has been at a decline over the years. This chart that you see here is from the OECD, and the numbers here are from the OECD, showing significant declines globally in leniency applications. So I know they're down here, but at least you can take comfort in the fact that you're not alone. They're down in the US too, they're down in Europe, they're down pretty much everywhere. In fact, I suppose we in the Americas are doing a little bit better than Europe in terms of the numbers. And folks have hypothesized, well, what is causing this decline? I don't think anybody really knows the answer for sure, but we are making educated guesses based on what we're seeing. Some of those guesses are, as you heard from Melinda, is there a shift in enforcer focus, looking at big tech companies, looking at new types of potential cartel conduct, like at those in labor markets where there's not really a lot of legal precedent, so it's a newer area where companies may not be as comfortable coming in for leniency because it's still a little bit unsettled. In terms of international leniencies, there's also a question about whether enforcers are now more focused domestically than internationally. So labor markets by their nature are more domestic. You don't kind of ship workers back and forth across the, across borders typically. And 2, there's a lot of focus right now on government procurement, which tends to be more domestic because it's a domestic purchaser. And you'll hear a little bit more later today about concerns about how civil litigation might be impacting the attractiveness of leniency because you have this potential liability that exists mostly outside of the leniency program. And I think it also bears mentioning that I think right now there's also a little bit of a frayed relationship between the defense bar and the government. I think in the past, leniency was very much built on the cooperation model, whereas now I think the government is taking a more aggressive litigation-based model and relying less on cooperation, and that affects the relationship between the defense bar and the government enforcers, because now instead of let's figure out a way to work together to resolve this case, it's now, we're litigation adversaries. So if I'm on the defense side, I'm going to be much more wary about the information I'm going to share with the government if I think we're going to be litigation adversaries. But the DOJ has said it wants to litigate cases, it wants to promote a litigation model, and it's prerogative to make that decision. But I do think it has a cost, and that's affecting the relationship with parties that you really want to come in and cooperate. And finally, I'll also echo Melinda's optimistic note, where I think, at least for large multinational companies, I do think, maybe I'm saying I hope instead of I think, but I think the big cases, the high-profile cases that the DOJ has brought over the years, that plaintiffs have brought over the years, has had an effect, such that, you know, seeing all those headlines, seeing how big the fines and damages are, encourages companies to invest in compliance, because it's still cheaper to pay for a compliance program than it is to pay for, you know, the Bridgestone $425 million fine. So I do think that plays a role, especially for the larger companies that can afford to invest in compliance programs. And of course, leniency is only a tool, right? Like the leniency is one part of cartel enforcement, and it's a tool used to enforce the law. It's not, it doesn't exist for its own sake. It exists to make cartel enforcement more effective. But I think the numbers are clear that there's a direct correlation between the success of leniency and the success of cartel enforcement programs. At least in the US there is. So these are actually from the DOJ website, so I didn't make these charts myself. These are all on the DOJ website showing results over the years. And what they show is, in fiscal year 2022, the number of cases DOJ brought was tied for the lowest number since before 2013, so about a decade. And probably more than that, because I think the numbers were higher before 2013. It just wasn't included in the chart. If we're talking about criminal fines, it's the lowest, again, since before 2013, according to the DOJ chart. And based on my experience and memory, it's the lowest since before the year 2000, somewhere in the 1990s. There may have been a lower number, but every number 2000 going forward is higher than last year's total criminal fines. And you know, I also talked earlier about the shifting focus towards individual prosecutions and individual penalties, but you can see that the trend there also is going lower. So it's not the case that, you know, corporate fines are going lower because DOJ is increasing penalties for the individuals, which might explain the trade-off. Here, if you look at the numbers, average prison time for individuals is actually lower than it was in the past. So basically, all the numbers are down. Yes?
Andre, let me, if I understood rightly, the average prison sentence in months, that show that in 2029, 20 months, this is the maximum? This is the average?
It's an average, so that number is the average of all sentences in that period, so 2000 to 2009. If you average the sentence that every individual defendant served,
Right.
the average is 20 months. So you'll have some lower and some higher than that.
I understand. But if you compare this situation with the normal criminal chief,
Yeah.
what happened? In average, I thought preliminary, it's a little time to be in prison. Broadly speaking, in compare with normal criminal, in normal criminal court system. Do you think it's a regular number? Is this the right number in prison?
No, that's a really good, really insightful question, but also a very difficult one to answer, because I think it requires some value judgments in terms of, you know, how you compare the crimes, right? Whether kind of say like somebody who steals something on the street, what the value of that is compared to, you know, an antitrust, you know, really, because when you're colluding, you're really just stealing from your customers, right? So when you compare across, But I do think there are a lot of people who have the view that I think you're suggesting, which is there's a view that white-collar criminals are not punished severely enough when you compare it to non-white-collar crimes.
Yeah.
I think a lot of people have that belief, and that, I think, is one of the factors that motivates DOJ to say we need to be more stricter on the individual white-collar criminals, because it's not enough of a deterrent to say, well, the company's got to pay $100 million, because really the shareholders are paying that. It's not the person doing the conduct. If the person's not serving enough prison time, then maybe it's not enough of a deterrent, so we really need to make sure that they're punished. So I do think, I think there are many people that think the punishment for white-collar criminals should be more severe. One interesting fact, and this actually came up in a case I worked on many years ago, if you compare the antitrust kind of penalty calculation to the fraud penalty calculation, fraud actually goes up much, much higher.
Yeah.
So in one case I had, the judge basically said, well, in my view, antitrust is just a version of fraud. I don't understand why the sentences don't go up as severely as the fraud sentences do. So as the judge, what I'm going to do here is I'm going to apply the fraud penalties. Like, I don't care that you charge them with an antitrust case, because I think it's the same thing. So a guy who had his sentence under antitrust was about 20 months. His sentence under fraud was much higher, and the judge sentenced him to 48 months.
Okay.
Much, much higher than a standard antitrust offender, because the judge thought, why are we treating antitrust criminals less severely than we're treating fraud criminals? These are really the same thing. So on to suggestions about how to strengthen leniency incentives. Kind of knowing how important leniency is to an effective cartel enforcement program. Really, it's about preserving the benefits, maintaining predictability and transparency. And I should pause here also and note that, as I said earlier, leniency is really just a part of, a very important part of, but is not the entire cartel enforcement program. So there also should be other methods to discover cartels, because that creates the fear of detection that leniency relies on. But in terms of preserving the benefits, the things that matter are, obviously the protection for the company when it comes in and wants to know it has protection, how the leniency program covers employees, because companies oftentimes, care what happens to their employees and want to make sure that if they can engage in conduct on behalf of the company, that they get treated fairly as well. Of course, you'll be hearing about this more, the civil damages protections. Just some examples here in terms of the top criminal penalties in the US that companies are seeking to avoid when they apply for leniency. Some of these are pretty severe. The maximum is $925 million for a company and 60 months for an individual. And as I said earlier, threat of detection is key. So enforcers should be, as a supplement to leniency, also engaging in ex officio investigations to create that fear of detection that will encourage companies to come in. And in terms of predictability and transparency, again, the benefits should be made clear to leniency applicants, that there's a clear difference in outcomes. If you come in, you don't get prosecuted, here are all the nice things that you get, but if you don't come in, you will get hammered. Leniency applicants need that clear difference when they're deciding to come in. Also, the obligations should be clear. Just doing a little bit of reading, I understand that there's been some issues here in the past in Mexico in terms of leniency applications being revoked. That happened in the US some years ago as well. And of course, leniency applicants must meet their obligations, but as part of that, I think enforcers have a duty to make sure you don't surprise your applicants in terms of how you're viewing their cooperation. There should be constant communication, and if they're falling short in some way, let them know. Give them a chance to correct it if it's a good faith shortcoming. Because it's in everyone's interest for leniency applicants to trust that they will be treated fairly and given an opportunity to correct any issues, and that leniency is not a game of gotcha where if you make one mistake, you get kicked out and prosecuted. And I'll close with some practice tips for the private lawyers in the audience. And I'll go through these one at a time. First is be proactive. And by that I mean, really, I think the first key step is encouraging your clients to invest in good compliance programs. Number one, prevention is always better than treatment, so if they can prevent the conduct, they're better off. And two, even if they don't prevent the conduct, if you have a good compliance program, you're much more likely to discover the conduct so that you can go get leniency and not be prosecuted. So you have to have these procedures where you train employees in terms of what they can and can't do, but you also train them in how to report the conduct if they do discover it. Understand your timing. Leniency is a race. It only goes to the first company. So when you learn of a potential issue, think about what the underlying facts are. Was there a meeting where everybody kind of went their separate ways? So is somebody going to self-report before you, or is the conduct ongoing such that you may have a little bit more time? So understand the facts in terms of kind of how much time you might have to go into the government, because it is a race. And as I explained earlier, in the US, it's not just a race against the other companies, it's also a race against the government, because if the government learns of the conduct before you self-report, you get type B, which has much less protection. Another key factor is understanding the scope of the conduct. On this point that antitrust is just one version of fraud, it's important to figure out, well, are there other things happening? Is there other wrongdoing that constitute other offenses, whether it's fraud, some corruption or bribery, other criminal statutes that may be implicated, such that you have to think about those things, because leniency only covers the antitrust part and may not cover other crimes being committed as part of the overall course of conduct. So that's an important thing to think about, because you don't want to bring your client in for leniency only for them to get prosecuted for some other conduct that they might be committing as part of the overall conduct involved. Also, it's important to understand the collateral consequences. Again, what's going to happen with your employees. We'll talk about civil actions, but there's also things like regulatory disclosures. Do you have to file something in your securities filings regarding the government investigation? Are there other possible criminal actions that might take place? And are there collateral effects that might damage your business? For example, if you're a government contractor, will there be debarment issues where you will become ineligible to conduct business with the government? So these are different factors to think about. That's basically what I have prepared, but again, I welcome any questions or any comments that you all may have. And I'm not going to step down from the stage until I get at least one question. Oh.
Yeah. In Mexico's case, there has never been a criminal conviction. Some criminal prosecutions have been followed, but never resulted in a conviction. In your opinion, are criminal convictions therefore immunities necessary for a successful immunity program?
You mean is criminal immunity necessary for a successful program?
Yeah.
Yeah, and I recognize that the system in the U.S. is different because it's the same governmental agency that handles, the investigation and the criminal prosecution, whereas jurisdictions like Mexico, you have an administrative body, but you also have public prosecutors. It's the same in Canada as well, where it's a two-part system. I do think criminal immunity makes the leniency program more attractive. Whether it's necessary, I think, depends on the particular jurisdiction and the likelihood of criminal prosecution. But if you give somebody that immunity, you're giving them greater clarity in terms of, what the outcome will be. And again, if you want to make the leniency program as attractive as possible, it's helpful to say, well, it's not just the company that will be protected, but the employees will be protected too. And that encourages the employees to cooperate with the investigation. Because if I'm an employee, why would I cooperate with, for example, a Cofece investigation if I think the prosecutor is going to use that information to prosecute me? So I think it really helps individuals come in and cooperate. So I personally think it's an important factor.
Hello. Well, thank you very much. Hi.
Yes.
Thank you very much. First, and the second, well, if maybe I misunderstood it, but it seems like last year, DOJ implemented even more measures and requirements for the leniency program, maybe even to discouraging applicants, or rather than make it more attractive. So I don't know if there is an explanation from them why they imposed or they implemented this, because the numbers are clear that the cases are going down, and I don't know, it doesn't make sense, at least to me, for them to make this last year.
Sure. And that all happened after my DOJ departure, so I'm just going to speculate as to what they were thinking. I think one thing that DOJ is thinking about is not just the quantity of leniency applications, it's the quality of the leniency application. And I think what those measures are designed to do is to basically kind of filter out what DOJ views as kind of poor quality leniency applications. So DOJ is basically making a trade-off of, yeah, we're going to make it more difficult such that only the good, only high-quality leniency applications will come in, and maybe we lose some other applications that aren't as good in terms of evidence. And for example, the prompt reporting requirement, one problem with some leniency applications is, they might come in years after the conduct actually happened. At that point, the evidence is old, it's stale, it's going to be difficult to investigate, it's going to be difficult to bring a case. So if you're DOJ, you might think, well, I don't really want those anyway. So it's okay to create a policy where that leniency application is no longer eligible. Now, I think the price of that decision is, you don't always know how good quality a leniency application is when it comes in. Sometimes it takes a little bit of investigating to figure out kind of how good that case is. And by kind of cutting off those cases early, DOJ may be losing out on a few good quality investigations, while at the same time filtering out the ones that they don't want anyway. So I think it's a value judgment of quality over quantity, but one with limited information. So you might also be losing some high quality investigations.
Andre, if you don't mind, if I just also offer my speculations in response to that, because I think some of the other policies that they implemented, like requirement to pay restitution, to not contradict things that you've said to government regulators when you're in a civil case, makes sense in theory, right? There's already a statute saying you should pay your victims, right? And there are, so this is less for leniency applications, but more for guilty plea defendants later on. As a civil litigator, I've seen plea agreements, right? That say, we did these things, it was bad, we violated the law, and then they come to the civil case and they sit down in a deposition and they say, oh, we just said that wasn't really true, which is not, the law is on our side in that sense, like, well, it's too bad, that was a binding legal statement. But I think the DOJ is also trying to address problems that exist, and I think there may just have been a lot of negative consequences from those efforts that maybe they didn't fully foresee.
Hi, thank you so much, Andre. It was very interesting. I have a very quick question. You mentioned the obligation of prompt reporting, and I'm not sure if is there some guideline on how fast is prompt reporting? I mean, how much is that?
Yes, there is guidance for that. As I said earlier, the DOJ has these frequently asked questions about the leniency program. So one of the leniency FAQs, like one of the questions is, what does prompt reporting mean? So there is direct guidance on that. And essentially, I mean, it's a new policy, so we haven't quite seen how it works yet. But DOJ's position is essentially, it does not mean right away. Like, it allows time for a company to do a reasonable internal investigation before coming in to report. So there is, it recognizes that companies will have some time, especially the bigger the company, you might need to dig in a little bit more. So it doesn't mean if you learn about it today, you need to come in tomorrow. What kind of a reasonable internal investigation means probably differs depending on the situation. My personal rule of thumb is, I think as long as you come in within 30 days, you're probably still prompt. Again, that's just my personal rule of thumb. There's nothing in the guidance that says that. Because what DOJ is really after is companies that deliberately delay their reporting, for a significant period of time.
Andre, I have two questions.
Sure.
One, you said in the presentation, other recent change, if there are contradiction between that the company said lenient program and what he said in civil court, the existing chance that kicked out of the leniency program. How can happen that? You have civil court at the same time that you have a leniency program in development? This is my one question. And the second question is more ideological. It's a surprise to me that you show the decline of the leniency program around the world. And I don't know if this is a ideological problem with the situation, for example, what happened in your criminal system with plea bargain. We know, maybe now it's different, but we know that is around 98% of the criminal cases in the US are plea bargain. It's just 2% that are going to trial.
Yes.
That means plea bargain is really an important tool in criminal court, but this is no decline. And what happened here? The leniency program is quite similar to a plea bargain. It's like the other hand in antitrust law. Why in criminal law, in criminal system, is no decline, and why in antitrust law there are?
Yeah, no, that's an interesting question. Let me start with your second question, and then we'll talk about the first, and maybe Melinda has thoughts about the first as well. Yeah, I think, one thing I would start with is drawing a distinction between criminal antitrust cases and criminal cases overall. Because obviously criminal cases overall is a much larger set, encompasses all sorts of different kinds of conduct, like the kind of what you talked about where 90% or 98% are pled out and only 2% go to trial. So I'm going to put kind of the broader universe aside and just talk about criminal antitrust cases, because what you're seeing in criminal antitrust cases is there is a decline in plea bargains. Defendants are much more likely to go to trial and much less likely to enter into a deal with the government. So it's consistent with the leniency decline. Leniency applications are down, but I think if you look at plea bargains in antitrust cases, that is also down. That's why you see so many more trials today than you used to. For example, the auto parts example I mentioned, no individual went to trial. So I think there is a parallel there if you just look at the criminal antitrust world. And I think part of what's driving that is the point I made earlier, which is litigation versus cooperation, because any bargain requires cooperation. And I think the current enforcer mindset is let's focus on litigation. On your first question, so oftentimes the DOJ investigation will be happening at the same time as the civil case. I understand here it's kind of one after the other. So first you have the administrative action and then potentially a civil action after that. In the US, the timing proceeds independently. So there are cases where they're happening at the same time. There have been cases where the civil action is actually first and the DOJ investigation happens after, because DOJ sees the allegations in the civil case and says, that looks interesting, let's investigate. So they can happen at the same time. So you do have situations where parties are giving statements to both sides. And as much as Melinda and her colleagues don't want witnesses contradicting the admissions in the DOJ side of the case, DOJ also doesn't want them contradicting those admissions, because DOJ may need those individuals as witnesses in a later trial. And the last thing they want is that individual under oath in a deposition denying the conduct. But Melinda, I don't know if you have anything to add.
Thank you very much. You mentioned the auto parts case as a successful case for leniency plus, and you also mentioned penalty plus. Is there any development with respect to these programs in the US, and if there is any relation with the new requirements that are for the leniency programs in the US?
Yeah, that's a really good question. There haven't been any changes to that policy. So it's still the same policy as it was before, but because leniency plus kind of incorporates the leniency requirements, whatever happens with the overall leniency requirements will always affect that. And as a company, you still do have a choice of, we're under investigation here, should we ask for leniency here? But if we think leniency is unattractive and doesn't really give us much, maybe we just fight everything, right? Instead of saying, I'll cooperate here, but not here, let's just not cooperate on anything at all. And that's a decision that companies might be making.
Thank you very much, Mr. Guevarola, for your time and for your knowledge and sharing your ideas with us.
Thank you.
Now, according to our program, we have a coffee break. We kindly request that you be here at this room before quarter to 12 to resume with our activities. Thank you. experience. In this roundtable, we will have Commissioner Andrea Marvan as our moderator. Andrea was appointed Commissioner at the Federal Economic Competition Commission in December 2022. Previously, she served as General Director of Competition Advocacy, an area in charge of coordinating Cofece's advocacy efforts with the public, private, and academic sectors. She holds a law degree from Universidad Iberoamericana and a Master of Law degree from the University of Chicago. As speakers in our roundtable, we have the honor to welcome Ms. Melinda Coolidge, Chair of the International Cartel Task Force at the American Bar Association, who we presented during our welcoming session. In this roundtable, we will also be joined by Alfonso Miranda, partner at Esguerra Abogados. Mr. Miranda began his professional practice in Colombia, focused mainly on competition law, an area in which he has advised different companies and in which he has acted as attorney in some of the most important cases discussed in Colombia regarding restrictive competition practices, mergers, consumer protection, legal metrology, and protection of personal data. Between 1987 and 1988, he worked as a lawyer in the legal department for Latin America at Bank of America. Between 2002 and 2021, he was the director of the Department of Economic Law of the Faculty of Legal Sciences of the Universidad Javeriana. We will also have the participation of Carlos Mena Labarte, partner at Krill Garcia Cuellar, Aiza y Enriquez, specializing in the areas of economic competition, investigations, and regulatory compliance. He graduated as a lawyer from the Mexican Autonomous Technological Institute. He has a master's degree in business law from the Madrid Bar Association in Spain, which he received with notable mention in 2004. He also has a master's degree in economic regulation from the London School of Economics and Political Science, where he received an award for the best performance of his generation in 2005. He was selected as one of the top 40 competition lawyers under 40 in the world by Global Competition Review, and collaborated as the head of the Investigative Authority, Director General of Investigations in Absolute Monopolistic Practices, and head of the Planning, Liaison, and International Affairs Unit at Cofece. We will also have the participation of Professor Juan Carlos Marin, who serves as an alternate chief lawyer of the State Defense Council of Chile. Juan Carlos Marin was a research professor at the School of Government and Public Transformation at the Tecnológico de Monterrey. In 2018, he assumed his new position in the organization that is responsible for legally representing public entities of the state of Chile and exercising the criminal action in corruption cases. Dr. Marin monitors compliance with instructions issued by the State Defense Council of Chile and advises the president of this institution on matters pertaining to the judicial defense of the Chilean state. I hereby give the floor to our speakers.
Can you hear me? We're good? Okay. Thank you, Rodrigo. Welcome to everyone. It's an honor to be moderating this panel. Before we start with the questions, which I'll be just very brief so that we can hear our expert speakers, I'll give just 2 minutes of context. For more than 10 years, the Mexican competition law has included in their provisions provisions that allow for private enforcement of competition through individual and collective actions. However, these provisions have not been implemented, and there have not been a lot of successful cases, or not any successful case, I would say. Just to give some detail, the provisions require a decision from Cofece in order for the actions to be initiated. And regarding collective actions, Cofece can file the collective actions. So this is just to give a bit of context. Today, we are honored to have a panel of experts like Melinda, who leads a competition private enforcement practice in the US. We also have 2 experts from Latin America who can give us their key insights or point of view of what is happening with private actions in competition in Latin America. And we also have Carlos, who is a Mexican practitioner, and can tell us a bit about the concerns or issues of the members of the private practice in Mexico and why this hasn't worked yet. I will start by turning to Melinda, if that's okay. Good. The US are pioneers and frontrunners of private enforcement for antitrust violations. We would really appreciate just a brief overview of how this has worked and evolved. And particularly, I think a topic that would be very interesting which is different from what could happen here in Mexico, is that damages claims for antitrust violations have been actually brought before a competition investigation. So what is your experience with handling these cases?
Sure, thank you. So as I was speaking with some of your colleagues and maybe also with you last night, I was speculating that if American class actions had to start with a law the way it is now, I'm not sure we would be where we are today. The law used to be a lot easier to bring a class action, to make it pass a motion to dismiss, to get discovery, to get class certification, which is a big hurdle to sort of, class certification means you've shown that you have a cohesive group of individuals or businesses that belong together in this class, and that you've shown that they were impacted by a cartel. And the law, I actually didn't get to experience that in my career in the last 13 years, but I've heard it used to be a lot easier. And the way it is now, our cases are the nightmare situation that I hear from you all. They do go on for 8 to 10 years, 8 to 12 years. I'm in a case that was filed in 2007, and it's still going. They are very expensive, and they're tough to litigate. You've heard from me, I'm a believer in these cases. I believe that they are really important avenues to seek redress for victims of cartels and competition violations, which is why we still do them. And it means, what are we looking for? We need, obviously, to have jurisdiction, but then we need a big enough pool, right? We can't go after small cartels with not enough volume of commerce. We can only go after the big ones, because we are going to be putting our own money on the line, litigating this for many years, and hoping to get an upside that made that worth it, right? For us as lawyers, and then obviously for the class as well. And you had asked about what happens when we go first. So I hear in the old days it also used to be easier in that the DOJ was always in front, always had the guilty pleas, and the plaintiff's lawyers would then follow those and do sort of the flip side. The DOJ would be doing a criminal, the plaintiff's lawyers would be doing the civil, and making sure that redress was given to the paid to the victims. These days, for a number of reasons we'll probably explore, many of them covered by Andre this morning, we haven't had that. We haven't had rafts of guilty pleas really since, and we did in auto parts and we did in broiler chickens, but there are lots more class actions being litigated privately that the DOJ did not start. And we litigate these and find out about these, sometimes from whistleblowers, sometimes it appears to be the case from a newspaper article, and we dig in and we find enough to file a complaint. There can be issues, right, with this. We always like if the DOJ does, come in and say, hey, there does seem to be something here. They'll then usually ask us to pause the litigation so that they don't end up with contradictory rulings or statements that aren't going to help them in their criminal action. It would be nice if we didn't have to pause, but I understand the reasoning behind that. But a lot of times we'll just go forward and litigate it all on our own. And the only way I think this can be successful is with a regime that allows for discovery or disclosure. I think it's a lost cause. Without that, I don't understand how it could possibly be successful. Cartels are secretive. Victims don't know what happened, right? They don't have access to the documents. They don't have access to witness interviews. They can't find out, who was talking to who and what they agreed on. They clearly don't have access to all of the transactional data that underlies the purchases that took place under the cartel. And expert is going to need that. We usually hire expert economists to prove, once we prove the liability, they'll prove causation, right? I see that these actions resulted in this amount of damage using the transaction data and some kind of econometric model. And if you don't have access to all of that, there's just no point in bringing a case. So I'm very curious to learn more about how private lawyers could undertake this in Mexico if they have access to, documents that Cofece has collected, or if there might be some motivation to change a statute or change the way these cases could be litigated so that private claimants could get access to that discovery.
I think those are great points. And before I'm going to first turn to our Latin American experiences, and then I'll go to Mexico. But just before I turn to them, I think you mentioned one aspect, but there might be others, and I think it would be good to discuss them or just to bring them. From your point of view, what makes a big case or a case that can be a big hit in private enforcement? You mentioned it should be a big cartel, because obviously if the damage is really low, then it's not enough, because it takes a long time to litigate those cases and to actually see the results. But do you have any other points that you think are important that make like a checklist or qualify for a big case?
Yeah, it's really about the volume of commerce. So, when we're looking at whether we're going to take a case, there's evidence that there's collusion, the first thing we do is say, okay, what's the relevant market, right? So that we can then look at whatever we can find in the public sphere about, how much is this company earning, selling this particular product. Usually you can find things in the public sphere that will sort of define the quantity for you and give you a sense. And if we can't, then we try to reach out to people in the industry and ask them, their opinions about, well, how much are you spending and things like this. And, we know we need a volume of commerce to be, say, definitely over 100 million, right, in the relevant time period. Of course, you have to know what the relevant time period is. It's hard to figure out how long a cartel's been going on. But we're looking usually at things that are more like 1 billion of VOC, volume of commerce, because then, that's not all damage, right? There's a portion of that would be damage, and then we expect our settlements to be a portion of the damage, so it's getting smaller and smaller. So for us, it's really about that size. I am a big fan of cartels that have lots of different participants, right? If we're looking at what to file, there are more opportunities to get somebody in the settlement door and the cooperation door if there's a lot of participants, but that's not a prerequisite. It's really about volume of commerce for me anyway.
Thank you. So I guess it all comes down to the money, right? It makes sense. It's a business. I think I'm going to turn now to our Latin American experts. I'm going to turn first to Alfonso, which something that we were speaking of yesterday, and I think you mentioned perfectly, or we related to what you mentioned perfectly, is Latin American competition agencies are very different from the American model of competition agencies. There's usually an administrative agency who investigates, sanctions, and then it's reviewed by the courts. The Chilean case is a bit different, but with this insight or relation between the Latin American competition systems, what is your assessment of the situation in private enforcement in competition?
Thank you. Thank you very much for the invitation. It's great to be here. Well, my view is that competition law in Latin America has evolved very well in the last 40 years, but we are like in Europe with, as you said, with a public enforcement system. where we have our competition agency, which is an administrative agency, and conducts an administrative investigation that ends in the definition of whether there was a violation of competition law. If there was a violation, prohibits the conduct and imposes a fine. And this fine is for the national treasurer, for the authority, for Hacienda. There is a part of the damage that is not addressed, because the objective of the fine is the deterrence of the conduct, and it doesn't take care of the damages that the private persons who have suffered an injury because of the anti-competitive conduct. And this has to be addressed in our countries with other kinds of legal actions, whereas in the countries like in the United States, where there is a private enforcement, where more than 80% of the cases are brought up by private litigation, and of course there is the authorities, the DOJ and the FTC, who can also bring cases, but the majority of the cases are brought by private litigation, and there is a huge incentive because of the treble damage system that gives 3 times the amount of the damage to the person who litigates and wins in an antitrust case, and that's why the American antitrust law has such vigor and has created this incredible doctrine for more than 100 years. But in Latin America, what we have, and in Europe, it's very important to address the issue of the damages caused by particular parties. And for that, for instance, in Europe, they issued the decision 104 in 2014 to promote that there are these legal actions. Now, one of the things that we have been considering in this interaction with Cofece is that the civil litigation may become a deterrent to the leniency program. Because if you are a leniency applicant, you have to confess that you committed the infraction. And if this is public to everybody, and all your documents are public immediately to everybody, probably you are the only one who is going to be sued, and probably you are the only one who is going to end up paying for the damages. And this creates a deterrence for the leniency program. Now, the leniency program is, as Andre showed us, is a very important part of the antitrust system, because it's the most effective tool in the fight against cartels. So since in the 90s the United States was so successful with the Golden Rule to implement an effective leniency program, it has been very important for the other countries to follow suit and have an active leniency program, and we are seeing this decline. And so it's very worrying, all these additional requirements that the United States have presented that make it more difficult, the type A, the type B, the necessity of restitution, and all those things that make it more difficult. And I would add something to that. We have to consider the multi-jurisdictional cases, where you probably, the case touches more than one country, and you are subject to different requirements to achieve leniency. And why would you go and present a leniency application if you are going to, with that leniency application, they can investigate you and fine you in all the other countries? Then it becomes a deterrent. And for the Latin American region, I want to also add to that problem that we have in Colombia, Ecuador, Peru, and Bolivia. We have the Andean Community, which has Decision 608 of the Andean Community, that is a very good antitrust statute, but for the problem that it has no leniency program, because it's an statute from 2005, and the majority of Mexico is 2006, and Colombia is 2009, the leniency program. So now the leniency programs are important, but the Andean community, who is a supranational competition authority that can decide that a case has a community dimension and will start an antitrust investigation of Andean scope, has no leniency program. And we have seen this, for instance, in the Kimberly-Clark case, where Kimberly-Clark and Familia had presented successful leniency applications. As a matter of fact, the Kimberly case is the most important case in Colombia for leniency, the most successful. It started with diapers, and because of the internal investigation, it went to soft paper, it went to notebooks, it went to Peru, it went to Ecuador, and very important cartel was dismantled because of this leniency application of Kimberly-Clark. But Kimberly-Clark went also to Ecuador, where the SCPM, the Superintendents for Competition in Ecuador, initially opened an investigation with Kimberly-Clark as an applicant, but closed the investigation, took all the self-incriminatory and confidential information that Kimberly-Clark had presented, and with that information accused Kimberly-Clark and Familia before the Andean community. And the Andean community that had no significant case, the only cases were 2 or 3 for saying there's no community dimension, but now they opened an investigation, conducted an investigation to companies that had already a successful leniency application over the same facts in each of the countries and imposed fines. Now this case is before the Andean Tribunal. But of course, a situation like this, where you can, if you go to leniency, then this information can be used to make other investigations in other parts and impose fines to you. This creates also a very important deterrence. So I think that we have to perfect the incentives for leniency, and we have, of course, to create the correct incentives so that in our countries there is the civil cases in order to indemnify the damages caused by the anti-competitive conduct. From what we heard yesterday, my view in regard to Mexico is that this prejudiciality, where only after Cofece has produced a decision can anybody sue, is very complex. And in any event, it doesn't match with the prescription times, because if the prescription is from the time of the conduct and Cofece takes some time to make the investigation, there's not going to be time to make the lawsuit. So at least there should be a change in that the prescription time, the statute of limitations should only run after Cofece has produced the decision.
I think those are very interesting points, and it's funny that you bring up the toilet paper case, because Professor Marin is actually going to speak about that case today. But before I turn to him, I'm just going to throw a question. It's going to be directed to you, but anyone can jump in, because Melinda was saying that something important for a successful case is discovery. You mentioned it as a key characteristic, and then what you're mentioning is, and I understand, is you have to be very careful and protect leniency applicants. So how can you handle these two issues or questions in policy to create something that you have leniency applicants from one point and you have successful investigations, and then from the other hand, you have private enforcement that's not damaged by leniency?
Thank you. That's a great question, and I am totally in agreement with Melinda when she says discovery is crucial, and we don't want to say that the information from the leniency applicant has to be concealed forever. But the response from Europe, and in Colombia now the rule is that the leniency file will only be revealed after the authority renders the decision. Why? This is all because of the golden rule, which is a standard that I see very damaged by the latest decisions in the United States, by the latest developments in the United States. The golden rule means that the leniency applicant should never be in a more difficult position than the other investigated parties who are not cooperating with the authority. So if you, once the leniency applicant presents his information and obtains leniency, all this information is available to the potential plaintiffs. They will immediately sue him, and he already confessed. And so he's going to be in a lesser position than the other guys who, at least for some time, they will say, no, I didn't do it, it's him, he is saying that he did it, that's his problem, and I am not part of it, and they will be able to defend themselves, and they are covered by their presumption of innocence and their right to defense and all that. But then at least the information of the leniency applicant has been confidential until the company makes the decision. And that's the way to coordinate those two interests, to allow for the lawsuits and also to protect the leniency program.
Thank you. I think Carlos wants to add up.
Say that that coordination that you mentioned, Alfonso, can be very difficult in our systems. So for me, it would be ideal to have a different incentive in the civil law setting, like the ACPERA or something like that, the traveling of damages, something that helps in the civil side of litigation and protect at all costs the leniency program. I think it would be very worrisome for companies, very difficult for practitioners to handle something to the government, to the Cofece, for example, that can be used against you in the civil setting, and that Cofece can give a judge and give the leniency file, then that would create a big disincentive. So I think it would be better to separate the two programs.
Yeah. Go ahead.
Thanks. So in the U.S., we typically don't get, I've never gotten, an actual statement by a leniency applicant to the DOJ. But what we do get is all the documents they turned over to the DOJ, right? Contemporaneous file. We also get access to that in discovery. So from my perspective, the reality is, if what we're given access to is, you know, the DOJ issued a CID, ran some search terms, also maybe did a dawn raid, got a bunch of irrelevant information, right? The search terms are probably better. And then we also do search terms for everybody else. Everyone's on the same playing field in that sense. It's not like the leniency applicant is worse off. Plus the combination of what Carlos said with ACPERA, guaranteeing the leniency applicant is limited to single damages and not joint and several liability, that's making them better off, right? So I would say to hold back the documents that a leniency applicant gave to the competition authority for a certain amount of time, it doesn't make a ton of sense to me. Like, so then we're gonna do discovery against the other companies, we're gonna get all the things, we're later gonna get the file against the leniency applicant. It's not like we take one defendant at a time, right? They're all in the same case. We're gonna spend a year or two in discovery. Like, what's the point of holding on to the leniency file for a certain amount of time, as long as it doesn't contain, I get the argument, if it did contain like a lawyer proffer, like we did this, we did that, you know, then I understand. But if it's just contemporaneous documents, I don't see the problem. I'm biased.
Thank you. I don't know if anyone wants to add. We're going to continue, I think, this discussion, but it's important to hear the point of view or what Professor Marin has to say, because Professor Marin has studied a lot a Chilean case, which is one of the very few successful damages claims that has been successful in Latin America. So please.
I apologize because I'm going to speak slow and clear. Hopefully, you can understand what I am saying. Because, as Celia Cruz said, my English is not very good looking. So, I'm sorry. So thank you very much to Cofece and Commissioner Andrea Marvan for this invitation. I'm really pleased here. Yeah, let me, in a few seconds, to try to explain how competition procedure works in Chile. Because it's kind of different from Mexico, for example. We have two competition authority. We have the Fiscalía Nacional Económica, FNE. This is a prosecutor. They investigate and they decide to sue the company who illegally affect the free market in Chile. And we have a court, Tribunal de Defensa de la Libre Competencia. And this court, that means a jurisdiction competition, okay? This is the system. And at the end, the last word have the Supreme Court. You have a remedy, it's like an appeal to the decision to the Tribunal de Defensa de la Libre Competencia to go to Supreme Court, and that's it, no more. So the cases are relatively swift, 2 years or 4 years, until Supreme Court said, that's enough. Okay, let me explain one experience we have in a tissue paper case, mainly toilet paper case. This involved two companies. They have an agreement in order to share the market, toilet market paper, and 25% for one, 75% for other one. And the big one is Chilean company. The second one is a Swedish company. Okay. There are two interesting issues in this case. The first one, we have, that was a lot of surprise for Chilean lawyers, we have at the same time two procedures against this company. One in competition court, and the second one in civil court. And it's supposed the Chilean law system in competition follow the follow-on system. So you have to wait for the decision to the Tribunal de Defensa de la Libre Competencia of the Supreme Court. And after that, if you think you have damages to recovery, you have to sue in a civil court. In this time, I'm talking more or less 2008. Okay? Okay. I'm going to refer the civil case a little later. And now I want to focus in the first one, in competition authority. Okay? Yeah. This was a cartel, this was an agreement, it was a collusion in this paper issue. And both companies, a few minutes ago, Andres said, this is a race for leaning program. Exactly was a race. And the Chilean company requests for this program. And this company reached an agreement with the Fiscalía Nacional Económica. The Fiscalía Nacional Económica decides if you apply, if you request, if you comply with all the requirements that the law exists. By the way, I gave you a document. This in one phase you have the Chilean law in English, and in the other in Spanish. And the other is a civil case I'm going to refer later. Okay. So in this case, the funny issue was the Chilean company was the first who confessed the collusion and applied for exemption from dissolution and fine. And the Fiscalía Nacional Económica got it, say, okay, I agree with that. And a few months later, the Swedish company said the same. Hey, I want to apply too. I request for these lineage programs. Okay, the authority say, okay, but you are the second one. And according with the Chilean law, the second one have to prove additional background information and just can get reduction of the fine, no more than. But the Swiss company said, wait a moment. We have a problem here because the Chilean company was the organizer of this solution and exerced coercion against me because he threatened me if I don't go to the collusion, I'm going to be expelled for the Chilean market tissue paper. Okay? The Tribunal de Defensa de la Libre Competencia said, well, I don't believe you. So I believe to the Chilean company and condemn both for illegal activity against the free market in Chilean law. And condemn to the Swedish company to pay a fine and exempted the Chilean company to pay a fine because apply the Linux program agreement with the Fiscalía Nacional Económica. Clear? More or less? Okay. The Swedish company appealed and said to the Supreme Court, this is wrong. I was object of coercion. You have to reverse. And the Supreme Court said, yes, I agree. So the Supreme Court, in appeal, revoked the decision of the Tribunal de Defensa de la Libre Competencia. It condemned to pay a fine to the Chilean company. And the Swedish company said, hey, now I am the only guy who can run this. So I need you give me all the benefits that you gave, the Tribunal de Defensa de la Libre Competencia gave to the Chilean company. Because now I am the only one, I am the first. And the Supreme Court said, no, you are not the first. Because the first is just who arrived the first. It's a chronological time, no more. So, nevertheless, despite the fact I reject the decision of Tribunal de Defensa de la Libre Competencia in relation with immunity from Chilean company, you don't deserve this benefit. So at the end, the Chilean system condemned both companies to pay a fine. This was in the administrative court. But in the civil court was a similar discussion, but a non-profit association on base of consumer law sued the two companies. And the lawyers say, hey, wait a moment. We have a follow-on system. This is not possible. And the non-profit association said, well, I have right to access to justice. This is a different matter. This is a consumer law. And I have two confessions of the crime, two confessions of the illegal activity against free market. And you share the market, you increase the price. So you have to pay damages as all Chileans who use toilet paper. $500 million. This was a suit. The funny thing that happened in this trial was the main shareholder of the Chilean company, the name is Papelera. I used to work there many years ago. The main shareholder said to his lawyer, I don't want this trial. I don't want an agreement. And I want to pay the money who got illegally. So there's agreement, there was a settlement between the Chilean company and the old authority in consumer law, around 10 plaintiffs, and they reached an agreement, and the Chilean company paid $150 million. And how you translate this money to the people, to the victim? In Chile was easy, because we're just 18 million people. The sentence just have right to recover damages if you have under 18 years old. And all in Chile, all the inhabitants in Chile, we have a number. Before your name, you have a number. As soon as you're born, you have a number. My number is 9621-527-4. What is my number? 9621-527-4. 96. When you go to any authority, they don't ask your name, they ask your number. And funny situation is, your number is the same that all Chileans have and a bank account in the state bank. We have a Banco del Estado. So the money was translated around $10 for Chilean to our account in the bank. Really easy procedure to get the money. And the amount was no reclaim was sent to the government, to the percentile more poor people. And that's it. To proceed. The Swedish company go on with the trial, and he defended, and he won in the first instance, because the civil court, the judge, said, okay, we have a problem. We have to wait for the decision of the Tribunal de Defensa de la Libre Competencia and from the Supreme Court. And how you sued before that, you have no right to recover the damages. And this sentence is now in appeal civil court. And maybe if we can gather again the next year, I can tell you.
We will invite you.
For sure. Yeah. This is toilet paper case, very important.
Thank you, Professor. A very interesting and a great way to I don't know, put pins on of the issues. I think as you were telling the story, one issue came to mind, and I think anyone can jump in. I'll just ask this this question, and then we can go for questions to the audience. You mentioned that in the Chilean case, there was the antitrust investigation, and the private damages claim was based on consumer law. I think that's an important issue. In the US, it's not in cartel cases, but in the US you have the FTC, which is a competition and a consumer protection agency. In Mexico, it's not that way. You have Cofece, which is in charge of implementing competition or enforcing competition policy and investigating and sanctioning. But you also have a consumer protection authority, which is separate. I think, Melinda, your expertise would be great, but anyone can jump in. How do these two laws or protection laws intersect in private damages claims? 'Cause in Mexico, there is a private damages claims for damages caused in competition law, but there's also damages claims for damages caused in consumer law. So I think that's a great point that came from your exposition.
Yeah, I'm happy to speak to that. So, and this actually complicates another suggestion that we had talked about yesterday in terms of implementing competition appeal tribunals like they have in the UK, a court that is specifically educated and good at getting through these cases quickly. I think that's been very effective in the UK and seems like a great job, a great solution. But then that would limit your ability to bring...
It's actually specialized court in competition.
Yes, yes, but not for civil, right?
No, not.
Right, yeah. So the way it works in the US is if you have an antitrust action, you file in federal court anywhere in the country, depending on jurisdiction, right, where your defendants are, where the commerce is. And you can bring your antitrust claim But we commonly will have consumer claims in the same complaint. And so there's not really an effective nationwide consumer law like there is an antitrust law, but there are state statutes in certain states that are that have been applied nationwide. The idea being if you're doing commerce nationwide, including in California, then the California statute applies to you. And it is, some of the strongest ones are California. It's also how we get around, this is complex, but the Illinois BRIC rule. So under federal law, antitrust law, only the direct purchaser of a price fixed product has a standing to bring a claim under the federal antitrust statute. But under 18 states allow you to bring claims for indirect purchasers. And so we often will bring those as well, not in the same case. It would be a different class, a different group of people. But what it does allow you to do is, you know, when we file cases, we don't have the investigative file, right? We don't get pre-filing disclosure, so we have to do what we can to guess at what really happened and guess which statutes are going to be the most applicable. And we find out in discovery where we were right and wrong, and it allows us to adapt the case and the claims to the circumstances as they unfold, and allows for, you know, if something didn't fit perfectly under antitrust laws, but really was some kind of a consumer law violation, that's already there in your complaint, and you could go forward with that.
I don't know if anyone wants to jump in or.
In Chile now, we have a really big problem with the consumer law and with the competition law, and there's a big tension now because the consumer law was modified just 2 years ago. We have a problem.
I don't know.
Why? Because now.
Just put on the mic.
Sorry. Much better. We have two problems with the lineage program now in competition law with the consumer law. The first, if you see our statute in the document I gave you, you can see at the end of the paragraph said, under no circumstances might this regime of exemption or reduction be extended to compensation for resulting damages. So, as Andre explained before, there are tension between damages because you confess, you can use in civil court. I can explain this later. But the second problem that we have now is now in consumer law, we have fine too. That means the authority in competition law and in product law can fine the company with the same amount that the Tribunal de Defensa de la Libre Competencia can fine the companies in competition. So the problem for the company now to apply for lineage program is say, okay, I'm going to confess here in order to obtain immunity for the fine here in competition law. But in the other hand, I have no immunity for the damages to civil court, and I have no immunity now for product law, consumer law in different courts. And the fine, the amount is quite similar now. They're both really high now. So maybe this will be a big problem because I thought that in Chile there are optimist view about the lineage program, but now it could be declined with this issue. They modified the law 2 years ago.
Thank you, Professor. I think I'll throw it to Carlos, who hasn't had the chance to speak because we've all been very active. I think it would be great to have a remark of what is the perspective from the Mexican private practitioner side, what is happening, and then I'll turn it over for questions.
Right. So I think everybody in the room would agree that the Mexican system for claiming damages in competition violations is broken. I would say that everyone agrees, I think, that we need a good system. It's part of a good competition law system, a good competition policy, and it's an issue of justice. Like, it doesn't matter where you stand, it's just paying the victims, as Melinda was saying, it's just an issue of justice. But I think it's also an issue that we haven't touched on, that is perspective for the common people in the market. Like, they would really understand competition policy and like what Cofece is doing if at the end they also receive a check for a damage they've received in antitrust violation. So that's also very relevant in our context. I think we need a legislative change in Mexico, and I think we need the correct incentives, not only the incentives in the competition law, but the incentives in the civil law system. And I think we've mentioned that, no? But also I think it is very difficult to convince the legislators to do a change if we haven't tried it and if it's not evident that it's broken. So I think we have some attempts by the IMSS, by the Big Cola, by other companies trying to get damages, and they haven't been successful, mainly because of procedural issues. But I think Cofece should try also to initiate this kind of collective actions, this kind of class actions, to prove maybe that it is wrong, no? The statute of limitations, all these loopholes, all these problems that the system has. I think we need to prove that, no? And Cofece is the party that should indicate this with action. No?
Thank you. Any questions from the audience are more than welcome. We have time. I think there's 2 questions.
Hi, good afternoon. I have a question for Commissioner Marvan. It's about, I understand that under Article 77 of the local competition law, it says that if a procedure for absolute or relative monopolistic practices, there are some effects hampering consumers, the commission must refer the matter to the attorney office, who has a responsibility to investigate in the penal penal law, under the penal law. I would like to have a little bit of understanding of how many of these investigations have referred findings to this attorney office under this Article 77 of the competition law, because it seems that one of the problems is from the citizens who are not filing complaints about their damages from these nocive activities, but also it seems that there is a responsibility from Cofece to refer their findings and start this investigation on their side. So I would like to know a little bit more about what is doing Cofece to refer the investigations, their findings to maybe to the Fiscalía General de la República, or maybe to state attorney offices or the Profeco. Yes, that would be my question.
Thank you. I think that's a great question. Cofece is in constant communication and has agreements with the Consumer Protection Agency in order to cooperate regarding issues or matters that could affect consumers and could affect competition, or both issues. Also, not regarding consumer protection, but regarding other violations to other laws. For example, Cofece has referred cases to the Internal Controller Office, especially regarding public purchases that could involve not only a competition case, but also a corruption or a violation to to public procurement laws. So I think there has been done some issues regarding criminal or criminal accusations. Cofece has filed 2 criminal accusations regarding cartel cases, regarding to public, well, they were related to public purchases. But I think this power or this faculty, something that Carlos has mentioned, has or should be used more or more frequently in order to see what has not been working and how to fix it. I don't know if, thank you. Other questions?
Hello, I'd like to know your point of view because I think there's a trade-off between class actions here in Cofece and the leniency program. How this work, because the information that the applicant brings to Cofece could be used for the class actions that the same Cofece can interpone with the judicial power. Cofece has think about that.
Well, yeah, I think it's a key issue that you're mentioning. As I mentioned in the previous question, I think Cofece should evaluate how to use this power and what are the issues that are making it complicated in order to fix it. I think one issue that Alfonso mentioned was the statute of limitations. It's not really clear procedurally. In Cofece's case, or Cofece's power has the power to conduct or to investigate 10 years prior to initiating the investigation. The civil cases and collective actions cases have other rules regarding statute of limitations. So I think that is a key issue that has to be cleared out in order for the cases to start going. But I would say that also, I think Cofece does have an important role, but it's not only Cofece's role to start these collective actions. The private practice should also be encouraged, or I think these type of forums are important to hear what are the concerns of private parties and their incentives and how to align them in order to push for more private enforcement.
Just one thing that you mentioned at the end, there has to be economic incentives for lawyers to help the collective actions and to help this kind of individuals that they don't even know the law, they don't even know they have the right. So someone has to organize them. There are the NGOs and these kind of organizations. I think they haven't been effective in Mexico. So you need to have some incentives directly to the lawyers to participate in these cases.
I've been living here for 20 years, and I studied deeply the legal tort system, responsabilidad civil extracontractual, in Mexico. And the bad news is the general system doesn't work. This is not a moment to try to explain why our tort system in general, not in competition, in general, it doesn't work. There are many problems about it. But the good news is from the last year, the Supreme Court especially, but also tribunales colegiados, has been changing this situation. And now, for example, we have punitive damages. Okay, I know it was a wrong sentence. I think the Supreme Court confused pain and suffering, daño moral, with punitive damages. But the truth is, the court are applying now punitive damages. So I think maybe we can use now the new vision that the court have, not the act, not the statute. The statutes always have diminished the amount that the victim can recover. Why I not have idea But if you see all general system in all states and a specific system, always you have the same pattern. The act diminish your recovery. But the tribunals now and say this is unconstitutional. And now we have punitive damages. So I think the lawyer have to use this new tool because they are there now. It's on the table.
Thank you. We have 2 questions over there.
So I was wondering, like, if the Mexican system is not like the American system where the antitrust cases are criminally prosecuted, and most of the times the incentives for the leniency program can be seen like just a reduction in the fine. So it can be like analyzed by the applicants or the participants in cartels just like one more cost. I was wondering if Cofece has ever analyzed like a kind of benefit for the criminal actions for the applicants to the leniency program. Just like, I know it would be very hard because it would have to involve a cooperation between the authorities, between Cofece and the authority and the civil authorities and the consumer authorities. But maybe, I don't know if it could be a viable way to both like get an administrative fine, an administrative sanction for the offenders, and assess these consumer damage that has been made. I don't know if it has been like ever an analysis on this or if it would be like viable.
I think that is sort of what Carlos and the other experts in the table were saying, which is Cofece has to assess, and I really, honestly, I don't have an answer right now, but I think it's interesting to assess, or it will be interesting if the benefits of the leniency program shall be extended to consumer, to private enforcement more than consumer, as it is in criminal cases where the leniency applicant is exempted from any responsibility. Because that's the criminal code establishes that those who abide or apply for leniency and get leniency are going to be exempted from responsibility. So I think what has been discussed in the table is if this similar scheme, or maybe not all responsibility, but how it happens in the US, and instead of getting treble damages, which is ×3, you get just, I think, 1, right? Detrebling, which was a good term that was used in the table. Detrebling the damages, so maybe not just exempt the plaintiff of all responsibility, but maybe have a benefit because of being a leniency cooperator.
No, you're totally right. Our system regarding criminal sanctions works very well from my point of view. The criminal code directly protects the leniency program and directly states that it's only the investigative authority that can refer for criminal investigation the cases that it considers a criminal violation. I think that was a big win by Cofece when negotiating with Congress in 2014. That was an excellent protection, and I understand there's an interest in Congress to change that, to change who can refer this or who can initiate a criminal investigation for competition violations. And from my point of view, that would kill the leniency program. And that change is something that we should stop as an antitrust community from happening in the legislature. That would be a big change in the wrong direction.
I think we'll take Professor Marin's comment. One more last question. And
my concern about this topic, particular topic, but my concern is general. I thought that the world changed, at least Latin America changed. You know, if you see now the 10 South America countries, you can see all go to the left, with the exception of Uruguay, which is the best one, but it's a little one, 4 million people. But the big one, Mexico, Brazil, and Argentina, and all are the left. And Chile, the rising star, is on the left too now. And I think ideological, to the left people, doesn't like this kind of agreement, because it's always for the rich people. The poor people have to go to jail, but the rich people don't. The poor people have to pay, and the poor people don't get the money, but the rich people have no problem about that. So, my opinion, I thought, the decline, what happened in Latin America, I think that now has to do with this issue, ideological issue. I think now the authority, especially in my country, doesn't like this kind of agreement. Like doesn't kind all the agreement as in criminal system. I think this is a real problem now we confront in Latin America.
Hi. My question is if there's a way to get around the general perception that the more you cooperate, the more you self-incriminate in the civil proceedings, or the more you give proof to the civil actions against yourself.
Yeah, I'd be happy to. So you have to, I think this goes back to, right, how does discovery work? In the US, my view is we're very good at it. We're very good at getting all the relevant information. And so the fact that it has already been packaged by one company to the competition authority doesn't matter because we're gonna find it for everybody else. That's my view.
I think that will be all. Thank you to our panelists for an excellent panel. Thank you for everyone for coming.
Thank you to our speakers. Finally, José Neri Pérez Trujillo, Cofece's Head of Planning, Liaison and International Affairs Unit, will deliver the closing remarks for this joint event from the Mexican Federal Economic Competition Commission and the American Bar Association. José Neri is an economist by the Instituto Tecnológico de Monterrey and an MA in Public Policy by the University of Chicago. He has 20 years of professional experience on matters of competition and regulation, market analysis, planning, and evaluation. José Neri joined the extinct Federal Competition Commission in 2012 as Assistant Director General of Planning Evaluation, and afterwards he was appointed Director General of the same area. He's a professor at the Instituto Tecnológico Autónomo de México and at Tecnológico de Monterrey. Among his publications are Reform on Matters of Economic Competition, co-authored with former Cofece's President Alejandra Palacios, as well as Introductory Story of the Evolution of Market Power and its Impact on Welfare. I here give the floor to José Neri.
Thank you, Rodrigo. Okay. Yeah. Thank you very much to everybody for being here. It has been a really rich morning. Thank you. And a space for learning a lot from different experiences from different countries, and we are very thankful with the people from Mexico and from other countries who are being with us and are being following the transmission through our social networks, and we are very thankful for you to being with us. Thank you all for joining us today in what I think was a very productive discussion on the current trends and challenges of leniency programs and private actions. I want to thank the American Bar Association for coordinating with us with this event. Let me thank also to Melinda Coolidge. Thank you, Melinda, for being with us. Andre Guevarola. Andre probably is right there. Thank you, Andre. Alfonso Miranda from Colombia. Carlos Mena for making everything possible. Professor Juan Carlos Marin for sharing with us all his knowledge, and Jim Mochnik that also was very helpful, and all the people who also connect through Zoom and through other means in providing ideas, insightful ideas for all this discussion. To conclude, I would like to briefly outline the most important takeaways from presentations and discussions. I'll start by recapping the morning message given by Cofece's President Brenda Hernandez. In her opening remarks, she spoke about the importance of competition authorities having leniency programs, as these have proven to be, among others, a powerful tool to detect cartels. As she stressed, in the case of Mexico, the leniency programs has contributed to a significant increase in the number of cartel detect and sanctions. For example, since 2014, at least half of the cases for collusions were initiated ex officio, and this includes those cases initiated following a leniency application. However, Commissioner Hernandez also raised our attention on the issue that despite its effectiveness as a cartel detection tool, the number of leniency applications have decreased over the time, not only in Mexico, but across the world. This may be due to various reasons which were discussed over the course of today's event. On the other hand, Melinda Coolidge highlighted that collaborations is key to strengthen leniency programs and collaboration amongst competition agencies, as well as through exchanges of experiences with private sector. She also highlighted the importance of discussing why leniency applications have been declining around the world, and how this forum of discussion allowed to identify ideas about how to address these tendencies in order to ensure that markets work well and produce results that improve consumer welfare. Later, the keynote presentation of Andre Guevarella focused on learning about international best practices to strengthen the incentives of leniency programs. In this regard, in his intervention, Andre shared the United States history and experiences regarding the leniency program of his country, which is one of the most successful programs around the world. This was an interesting session, which allows us to understand all the changes that have taken place to this program in the United States, and that we can learn from that experience to improve our programs in our countries. In this session, Andre also shares some interesting cases, one of which was an international case where the leniency program was used as a very important antitrust tool, and share his perspective regarding the decline of leniency applications and the importance of conducting ex officio investigations by competition agencies. Later, and just before a few minutes finish, the roundtable, moderated by Commissioner Andrea Marvan and with the participation of Melinda Coolidge, Alfonso Miranda, Carlos Mena, and Juan Carlos Marin, provided an opportunity to hear the views on country experiences and lessons learned when balancing private and competition policy enforcement, particularly regarding leniency programs. Also, this roundtable provided the opportunity to hear experiences from Colombia, Chile, and the United States, which show some of the different challenges faced when implementing damages claims in these jurisdictions. Also, the roundtable offers some perspectives on how these challenges could be addressed. Finally, and to conclude, I would like to stress the message of President Chairwoman Brenda Hernandez when she mentioned that Cofece's leniency program is a useful and powerful tool, but it is not the only one that we have for anti-competitive conduct detection. The Commission has been very proactive with regards to other tools for cartel detection, such as those technological tools developed by Market Intelligence Unit. These technological tools, besides making our leniency program more attractive, ensure that Cofece rigorously enforces competition law and more efficiently investigates and sanctions cartels and other anti-competitive conducts that harm competition in the markets and adversely affect consumer welfare. Thank you, everybody, again for joining us today. And now, adjourn today's event. Have a nice afternoon.